Recording in progress. Good morning, good evening, wherever you are in the world. Welcome. I am Marco Buscema. I am an Italian attorney. I'm based in Udine, Italy Northeast, and I am the founder of Will. Proud to introduce a milestone for Will, another milestone for Will. In a few seconds, I will let the stage to the chairman of this session. So today we are proud to introduce a very interesting topic with great speakers. And for this, I will let Joseph Weinrauch from Tel Aviv, Israel, to introduce the session in detail and the speakers. Joseph, please go on, and thank you.
Thank you, Marco. Hello, everybody. My name is Joseph Weinrauch. I'm an Israeli attorney. We are going to introduce today our first joint essay of Will, where a few lawyers from different jurisdictions take a complex legal problem or legal issue and try to put their knowledge together and also combine it with outside professionals in order to show this issue, the complex issue, in a certain different ways from different jurisdictions with different experience, with different knowledge. Today, we are going to talk about the challenges to an arbitrator and judges, also about bias. I would like to thank my colleagues Lara, Francesca, and I would like to thank also our guest speaker, Shaul Manheim. He's a retired judge of the district court in Israel, an arbitrator and mediator for many years, that has contributed very much on our essay from the point of view of the Israeli law. So I think we should get started. At the end of the talks, there will be a Q&A session. So please be concentrated and try to challenge our speakers. And also everybody can introduce themselves briefly at the end of the session. First of all, I would like to let Marco introduce himself. Marco, please, 1-2 minutes, go ahead.
I try to stay in 1 minute because I guess you don't have 2 hours and it would be demanding for you. So thank you very much, Joseph. As I mentioned, I am Marco Buscema and I am the Will founder. I'm proud and I'm still not realizing what I am the spark for. So I have to thank all of you because you changed my life. So what we want to do with Will is really bettering the world. Lawyers can better the world. In this minute, I want to share that lawyers changed the world. Nelson Mandela was a lawyer. Mohandas Gandhi was a lawyer. And Abraham Lincoln was a lawyer. And Fidel Castro also was a lawyer. I think he's a divisive character, but he was also a lawyer. So somehow lawyers can influence the world with their profession. But normally we are concentrated, we are focused on conflict. And I'm very happy today to have, of course, lawyers focused on arbitration. There are challenges and the colleagues will speak about that. And also with Shaul Manheim, honor judge in Israel. Lawyers, judges, other stakeholders in the legal environment should speak to each other instead of being separated. Because together we can change the world with our vision. Will's vision is we dream of a world where the highest level of legal assistance is democratized and easily accessible globally for each individual, company, or entity. I close my short speech with my favorite quote from Walt Disney. We have 2 quotes. One is one official quote in Will. When the ants unite, they can move an elephant. It's an African proverb. And then my personal favorite quote, which is a Walt Disney's quote, if you can dream it, you can do it. Thank you very much.
Thank you, Marco, for your warm words. I would like everybody to mute their microphones because it might disturb. And now let's open the microphones and give an applause to Lara, who has birthday today. Happy birthday, dear Lara.
Let's say happy birthday in our own language. Buon compleanno.
Feliz cumpleaños.
Joyeux anniversaire.
Okay, now close your microphones, please. Okay, now Lara, please introduce yourself so everybody knows. We know your birthday, but what else? Please introduce yourself.
Good morning, or good afternoon, or good evening, depending on where you are in the world. My name is Dr. Lara Pair. I'm a triple qualified attorney, which means that I have bar admissions in the United States, in Germany, and in Switzerland. I focus on commercial law and arbitration, and that is what I do mostly here in Switzerland. What we'll be talking about today is challenges to arbitrators, how they're possible, when they're biased and when they're not. I'm proud to say that I was the instigator of the paper, and I'm even more proud to say that there's probably more contributions to the article coming. I want to thank Joseph for bringing the Honorable Judge Shaul Manheim in this group of ours to lend the judicial perspective, which is very nice. As for me personally, I dance salsa. Anybody is welcome to come to Zurich and dance with me. And I own cats.
Thank you, Lara. Thank you. Now, Francesca Sperti, please introduce yourself, please.
I'm Francesca Sperti. I'm a lawyer in Bologna, in Italy. My area are data protection law, IT law, and real estate. And I like very much arbitration, most of all, as I suggested to Lara. I would like to do arbitration related to technology. There is a specific arbitration chamber in California focused only on IT. And as you know, I have been appointed as Ministry of Gastronomy in our league. And I'm really proud of my country that I like to show to everyone who is interested in it. Thank you.
Thank you, Francesca. I will introduce myself briefly. My name is Joseph Weinrauch. I'm an Israeli attorney since 1987. I do mostly cross-border litigation, other litigation locally, insolvency, torts, and commercial. And I am responsible in our organization for the activity in the German-speaking countries through the group of Will Dach, and I'm also a member of the board. And I would like also to thank my dear colleagues again, Lara and Francesca, for raising the bar and showing everybody that it can be done. And I would like to thank also our guest speaker, Honorable Judge Shaul Manheim, who put in a lot of effort to help us, to assist us, and to broaden our knowledge in this complex issue. And I call on Shaul to introduce himself. Shaul, please. Stage is yours.
Thank you, Joseph. Thank you, Marco, and thank you, everybody. I am honored to be participating on this meeting today. A few words. I graduated my LLB degree in Tel Aviv University on 1981. I'm a lawyer since 1982. 15 years later, I became a judge, first in magistrate court, where I met Joseph, and then in the district court, which is practically the highest trial court in Israel, and also the Court of Appeal vis-a-vis the magistrate court and family court. I've been a judge for 15 years, and on 2012, I made an early retirement. Since then, I am acting as an arbitrator and mediator in Tel Aviv. My practice as a lawyer and then as a judge and now as an arbitrator and mediator is focused on commercial and civil law, including insurance, banking, torts, insolvency, real property, technology. I've had a very interesting career along the years. I also took my LLM degree about 15 years ago, also in Tel Aviv, commercial law. Not born in Israel, I was born in Poland, but at the age of 4, I came to Israel, and that's where I live since. Okay.
Thank you, Shaul, and I would like to kindly ask you to start to present the issue of challenges to arbitrators, the law in Israel. Please take your time and start. And everybody, please be concentrated and prepare questions. Thank you.
Okay, thank you again. Before I start diving into the details, I would like to say that this is a very unique thing to do, to take identical questions on a matter and try to see how different jurisdictions act with regard to same questions. Comparative law in its best and its most detailed form, that's a great thing to do. It's especially important nowadays when you all know it, borders are not really important anymore. Trade, people, capital, technology, knowledge, it all moves quite freely, and borders, political borders are not really an issue. Yet the law is still state law, and there's a lot to be done on this point of comparative law. The question that arises is with respect to judges and arbitrators, bias. How do you deal with it? What are the duties of the judge or the arbitrator? What are the duties of the parties? What's the sanction? First, in principle, the rules of what bias is and what's the result are quite similar in Israel between judges and arbitrators. Yet, there is some difference. You can see it not in the rules, but in the way they are applied by the court. It seems that arbitrators are expected to be more careful, are expected to disclose more information about themselves and their possible, I would say, contact with the parties, with the lawyers, or even with the field, the relevant field or relevant other aspects. There are a few reasons for this difference. We'll get to it in a few minutes. The result of bias. It can result in a nullification of the judgment, but that is relevant only if the bias is discovered after judgment was given. The more common thing is when bias is discovered or claimed during the process. And then the result would be nomination of another judge or another arbitrator. But in arbitration, there is also a possibility that the case will no longer be tried before an arbitrator, and will have to go to court. That is when court will be convinced that that the parties agreed only to the very specific arbitrator who unfortunately will not go on acting as arbitrator in this case because of problems like bias. In such a case, it goes to back to court, and this is a very problematic result, because in most cases arbitration is relevant for complex issues, complex conflicts, and if after a long time and hearing a lot of witnesses and getting a lot of documents and evidence, you have to start all over again in court, that's bad news. This, of course, calls for a party who feels is going to lose to try to find something wrong about the arbitrator and then go to court and say, you have to stop the arbitration and take the case to court from the beginning. When is an arbitrator or a judge considered biased? The test is objective. If the facts objectively show that the judge or arbitrator is not open to decide according to the evidence and to argument set before him, but has already made up his mind or is biased, like in that Swiss case that initiated all this. Here's something against, say, Chinese people, but you can rename it and say whatever class you want. What are the reasons that Israeli courts apply the rules more strictly upon arbitrators? And there's, in my opinion, there are three reasons. First of all, a judge cannot say, oh, I don't want to hear this case. I don't know, it's unpleasant for me. He cannot say that. Either he has a cause recognized by law to dismiss himself from the case, or he has to hear it and decide. An arbitrator can always say, I do not take that case. Before he starts acting, he can refuse. He doesn't have to explain why. He's in full liberty to decide to take a case or not to take a case, as long as he hadn't started acting as an arbitrator on that case. So arbitrators think deeply before you give a consent on a specific case. The other side of the same coin is if we look at the parties. In court, the parties do not choose the judge. The utmost can choose the court, but not the judge. In arbitration, the parties are at liberty to choose the arbitrator, or at least the mechanism that will choose the arbitrator. So they have to be fully informed before they really agree that the specific person will be the arbitrator on the specific case and conflict. The third reason is judges have in Israel a quite elaborate system that is designed to prevent conflict of interest and bias. They have an ombudsman, they have an ethics committee, they have ethic rules. All this does not apply to an arbitrator. An arbitrator, any person who all parties consented that he will be the arbitrator, he is the arbitrator. In Israel, he doesn't have to have any other qualification except for the agreement of the parties. there is no mechanism to supervise, there is no disciplinary tribunal, nothing. So he has to be more careful. But what does it mean to be more careful? So first of all, he has to disclose before the arbitration starts anything that might influence the consent of all parties for him acting as an arbitrator on that case. Even if it seems remote, even if it seems negligible, he has to say it. On the other hand, if it's really negligible and totally insignificant, and he hasn't disclosed it, probably the court will not act to replace him if a petition, if a motion is made. But my advice to arbitrators: if there is a doubt, there is no doubt. Come on, say it, even if you believe it's not relevant. The other side, let's talk about the parties. The parties, according to latest judgments in Israel, have also an active duty not only to disclose to the other party anything that came to their knowledge and might influence the other party's consent to the identity of the arbitrator, but also they have an active duty to take reasonable measures to check whether the arbitrator is biased. Now, the last thing I would like to say is, let's look at nowadays the digital information technology time when almost everybody is in LinkedIn, in Facebook, and Twitter, and etc. It seems to me that there is no Israeli case saying what are the reasonable measures a party should take to check before he starts an arbitration with a specific arbitrator. But I believe that a basic search in Google or similar search engine, in Facebook, LinkedIn, Twitter, that's basic. See what the person writes, what he likes, who are his friends and colleagues. You can know a lot. And that brings me back to that Chinese, Swiss case about the Chinese. Somebody wrote something on Facebook. So if they checked it before the arbitration started, this would all be solved. I believe that's all for now. The paper Joseph and me wrote is, of course, more elaborate and longer, and I'm here for any questions. Thank you very much.
Thank you, Shaul. Thank you very much.
Thank you. Great.
Yes, thank you. It is a great, it's a great honor for us to have your knowledge from all these years on the bench and also as an arbitrator. So you have you swim in this pond and you have the feeling for it. So thank you very much. Now I would like to ask our birthday girl Lara to continue by showing the challenges to arbitrators according to the law in Switzerland. Lara, if you can make it in 7 minutes, that would be good. Do you want me to keep the time?
Well, thank you very much. I will try to keep it brief. Like I said, like the Honorable Judge said before, the challenge reasons for judges and arbitrators are pretty much the same, but they're more strict in Switzerland. They are related to even the appearance, not the actual, but the appearance of bias or impartiality. Switzerland strongly relies on, even if they have not been added to the arbitration agreement, either through direct agreement or through an order by the arbitrators, on the IBA guidelines that subdivide into a red, a yellow, and a green list, whereby the red list is a waivable and a non-waivable red list. If you read my article, or the part of the article that contains my part on Switzerland, you will find it more directly, or you can look directly on the IBA guidelines themselves. They're very detailed. So those are the reasons that you can challenge an arbitrator. The way to do that is basically when the arbitrator is first appointed. There are very tight deadlines for the appointment of arbitrators that tell you when you should challenge. If you miss that challenge, you generally have lost the right to challenge. Now, in 2021, on 1st January 2021, prior to the judgment that the judge has already mentioned, namely the judgment that was rendered against the Chinese swimmer and then overturned by the Swiss Federal Supreme Court, there was no second bite at the apple. You could find the possibility to annul an award, because there's always a challenge of an arbitrator as first step. That's while the arbitration is ongoing. Then when the arbitration has finished, you had 30 days to find a reason to annul the award. And these reasons are basically the 5 reasons enumerated in the New York Convention. And now there has been a 3rd reason added, which was basically the same reason used in the Chinese swimmer case. Namely, and notably, before this enactment was actually introduced in the Swiss law, that you can now revise a judgment even after that judgment has been made, or that arbitral award has been made, and after the duration or the deadline for such a challenge has already expired. The only time limit you have there is discovering that there was bias, or the appearance of bias, or impartiality, or partiality, not impartiality. Then you have 90 days upon that discovery. Now, as stated in that Chinese swimmer case, the parties have quite a duty on them to actually research their judge, because they already have 2 bites at the apple. First, when the arbitrator is first appointed, and then within 30 days of the rendering of the award. And now with the 3rd being added, there's yet another opportunity. So the parties have a duty to research their arbitrator. And this is where it gets interesting in Switzerland. They're saying you need to do a Google search. You need to be mindful of what is publicly available, and you need to be thorough. However, you do need to take into account if there is a lot of different information. In this particular swimmer case, they were saying that the Twitter messages were so drowned in general Twitter messages of his that it was not necessary to look at every message for the past few years prior to the appointment, but that it would have had to be more prominent. You can see how that is problematic, because on the one hand, it imposes a generalized duty on the parties to do research, to do Google searches, and to even look at some of the main, how they call it, social media accounts. But on the other hand, it's then more relativistic to how the party has to do, depending on how active that particular arbitrator is on social media. The remedy that has been suggested in Switzerland by Swiss scholars is to put a generalized, as an arbitrator, to put a generalized disclaimer on their websites. I've also added that, saying that just because I'm friends with someone on Facebook, Twitter, or whatever, or just because I like a post about fluffy animals, doesn't mean that I would automatically have an opinion based on, the protection of fluffy animals. In this particular Chinese swimmer case, I think a lot, that's my personal opinion, I think a lot of the issue of what should have been done and what shouldn't have been done by the parties researching the case was the particular outrageousness of the claims made by the particular arbitrator about Chinese people as such. As a takeaway, in Switzerland, you don't only have the customary 2 bites at the apple in the country of origin of the award, but 3. And in addition, you have, according to the New York Convention, then a 4th bite at the apple wherever the enforcement is supposed to take place when you go against the recognition and enforcement of a particular arbitral award. That is all I can say about the bias and the challenges of arbitrators in Switzerland, and this particularly unique situation in Switzerland that we have 3 bites at the apple at this particular topic. Thank you very much for your attention.
Thank you, Lara. Thank you. Very interesting, and I think it was also very professionally in the proper depthness for this kind of 7-minute or 8-minute presentation. So thank you very much. And of course, everything is written more to be read in the article that will be published today, I hope. And thank you, Lara. Now we are turning to our Italian colleague, Francesca Sperti. Please take your 7 minutes and get started. Thank you.
So in Italy, we don't have an express prescription of impartiality. We only have expression is expressly mentioned in our constitution in the article 111, and is related to a fair process. But net of this constitutional reference, we don't have in our legal system an express prescription of conduct for arbitrators related to impartiality and independence. So what we can do is deduce this prescription from the hypotheses that are in our civil procedure code for the cases of recusal for arbitrators. When the legislator consider the absence of independence and impartiality. These are cases related to situation in which there are a personal or direct interest for the arbitrator, or also an indirect interest related to a relationship or friendship or habitual attendance with any of the party of the procedure. There is a difference among the cases in which the judge has the duty to abstain from the proceedings in relation to the arbitrator. One of the cases in which there is an hypothesis of a recusal for the arbitrator is also when he doesn't possess the qualification that have been expressly agreed by the parties. And so the qualification of the arbitrator, I was thinking about what the judge was saying before, to be established by the parties. We have not specific prescription about the qualification that the arbitrator have to possess. There are sources of heterogeneous nature that mention rules of conduct of arbitrators. For example, in main regulation of arbitration chamber or in the code of ethics for the lawyers. We can find a duty of conduct related to the behavior in a way to save the confidentiality of the information that the arbitrator possess related to his rule. Or, for example, the Milan Chamber of Commerce don't exclude from the opportunity or the possibility to be appointed as arbitrator lawyers or someone who is part of the board of directors of the arbitration council or who is employees of the arbitration chamber. In Italy, we can find, in the Italian legal system, we can find preventive remedies and subsequent instruments to solve issues related to impartiality and independence. The preventive remedies are most of all in the administrative arbitration. The declaration of independence is not mandatory in the arbitration that is is disciplined in the civil procedure code, but in the regulation of the Chamber of Commerce, there is the mandatory declaration of independence. And it has to be the arbitrator have to make this disclosure not only at the beginning before accepting the appointment, but also if the reason that question is duty of impartiality or independence arise during the procedure, he is obliged to make this declaration of independence. Also in the regulation of some Chamber of Commerce, the assignment for the arbitrators is subjected to the confirmation of the institution that can take in account reasons that are not included in the list that we have in the Article 815 of our Civil Procedure Code. Another preventive remedies is the no acceptance of the assignment by the arbitrators when there is well-founded doubts about his impartiality and independence, and of course the no acceptance of the assignment. There is in our legal system no burden on the party to previous investigation about these requirements, but rather burden of prompt reaction as soon as they became aware of the lack of one of these requirements. The rules and consequences concerning the lack of these requirements are very, there are more similarities than differences among judges and arbitrators. What I would like to underline is that the lack of an express prescriptions about a duty of impartiality and independence in our legal system can expose the arbitrators only to condemnation for remedies with the parties, but has no effects on the award. The trend that we are observing now in Italy is an increasing number of objection and observation on the position of arbitrators. Maybe it's because the arbitration are increasing, and in fact our government is doing a law, is thinking to do a law where the disclosure of independence is going to become mandatory, and are increasing the list of cases in which the arbitrator can be recusal. Thank you.
Mille grazie, grazie mille, Francesca. Thank you very much. Thank you. First of all, I would like to point out from the point of view of our organization that this is the first time that we are actually executing a comprehensive study on a legal issue that might occur in different jurisdictions, and 2 or 3 colleagues work together to bring the knowledge in their jurisdiction to our colleagues. So all of you who came today, you are the fortunate to witness how it can be done, and think about the potential that we in Will can bring different the knowledge and the opinions in different jurisdictions all together from our personal experience. That is not the same like, for example, an Italian lawyer would go to the library and try to understand the law on arbitrations in Israel and try to bring some rules that are occurring in Israel. But it is the experience of us, the lawyers who work in this field for Shaul, more than 40 years now, or something like that. So, I mean, that is the advantage, and I want you to be aware of that. So, first of all, let's open the microphone and let's clap to our speakers. To our speakers, thank you. Grazie. Vielen Dank, Lara.
Thank you.
May I say something before going to the Q&A session, Joseph?
Of course you may.
Yeah, this presentation is okay, just 30 seconds to underline, to highlight your incredible
30
work.
seconds or 30 minutes?
No, 30 seconds, but I have to speak, otherwise they will be 30 minutes. So thank you, Shaul, Joseph, Lara, and Francesca for your amazing job. You are part, Joseph, Lara, and Francesca, of a vertical group in Will International Disputes. You are representatives today for this, and it's a great cooperation. You met there. You didn't know each other before, and you met there. That's fantastic. So you produced a 29 pages contribution on arbitration, and this article will be available for all the Will affiliates in the Will's website, website reserved area for the people. So that's an invitation to upload your profile and to register there, because you will find this incredible contribution there. So thank you again, and may I help you just a second in order to, before the Q&A session now, but I would like people here, please, we have 10 minutes before ending the session, so be quick in introducing yourselves, 10 seconds each, and first the Will people, then the guests I see in the list. Can I, Joseph, go on with the people?
Of course you can.
Yeah, I asked because you are the chairman. So first question.
I like it when you help.
Yes, thank you. So Małgorzata Skawińska from Rzeszów, Poland. Małgorzata, please.
Hello everyone, I'm Małgorzata Skawińska from Poland. I am corporate lawyer, but I also very interested in alternative dispute resolution. From Saturday, I'm also the mediator. So yes, this is the path that I would like to go through, and I'm very congratulations for your work, for your effort. This is what I would like to see this in Will. Thank you.
Yeah, you will see it as long, but you were using the right words. Alternative dispute revolution. That could be very nice for as marketing. Let's go on. Katharina Heisch from Nuremberg, Germany.
Yes, hi, Katharina Heisch. I'm an IP and IT lawyer, also dealing with labor law in Nuremberg, and I'm also a trained mediator and very happy to be in Will and to have had the honor to hear this first session of legal cooperation in Will. Thank you.
Thank you, Katarina. Highlight on her because she decided recently to prolong a collaboration with Will. So thank you, Katarina, for the trust and for your strong effort to be here. Enrica Maggi from Klagenfurt, Austria, our Will CEO.
Hello, everyone. Congratulations to all the speakers today. My name is Enrica Maggi. I'm Italian, but I'm living and working as a lawyer in Austria, and I specialize in criminal and commercial law, and I am the CEO of this great professional network called Well.
Great. Thank you, Enrica. Pallavi Divekar from Mumbai, India.
A warm hello from me, Dr. Pallavi Divekar from Mumbai, India. I'm a partner of Divekar and Company, which is a 100-year law firm. I'm very proud to be a part of this association, Bill, and I think it was a super presentation today. Learned a lot, and I'm happy to introduce my visitor today, who will be speaking to you in just a few minutes as soon as Marco says.
I will let you, in a few seconds, you to introduce him. So then let's go on. And Beatrice Tascalanga from Karlsruhe, Germany.
Yes, hello everybody. I'm a German civil lawyer. I focus on family and inheritance law in cross-border issues. Thank you for this amazing presentation today. It was very, very interesting.
Thank you. So let's go to Naples, Italy. Fabio Marinelli. Fabio, okay, let's go to Canada then. Montreal, Fritz Gerald Morisseau.
Hello, my name is Fitzgerald Morisseau. I'm an attorney, business attorney, and IP. Thank you again for this fabulous presentation and to see all of you again. And thank you, Honorable Judge. Thank you, Lara. Thank you, Joseph. Thank you, Francesca.
So let's go to Africa with one of the two leaders for Will Africa, Kirti Biseswar from Durban, South Africa. Kirti.
Hi, everybody. It's a pleasure to be here and to be learning so much. Congratulations to our amazing presenters. I think you've done a fantastic job. I've been with Marco and this amazing team from 2017, and I am proud to be a member of the board and a part of this family. And I also am responsible with Akin for growing our brand of affiliates within the African continent. And it's been great to engage with all of you. Thank you, Joseph and Marco.
Thank you. Akin Sanda from Lagos, Nigeria. Justina Matuszak-Leżna from Warsaw, Poland.
Hello, here's Matuszak-Leżna. I'm Polish attorney based in Warsaw. I do company law, IT, data protection. Congratulations to all speakers. It was really great. Thank you.
Thank you. And then let's go to Spain. Jesus Rosa from Ferrol, Spain.
Thank you, Marco, and thank you, everybody, because this is a great opportunity. My name is Jesus Rosa. I'm a litigation lawyer in Ferrol, and as I am also a member of the Court of Arbitration in Ferrol, this is a great opportunity of knowing these things. Congratulations to all the presenters. Thank you very much.
Okay, so thank you, Jesus. Let's go to meet the guests we have. So Lara, would you like to introduce yours? Martin.
Definitely. I'm working with Martin on a case that I have in the area of corporate law. He has been very helpful. He's been doing a few things for me, and I'm probably going to give him a few more cases. I asked him to join Will because we have only one other attorney in the Czech Republic, and it is always helpful to have attorneys with different specializations in a specific country. As you can see with the DACH group, we are various attorneys from the same German-speaking countries. So please, Martin, introduce yourself.
Thank you, Lara. Thank you, Marco, for inviting me to this session. Hello, everyone. My name is Martin Hekel, and I'm an attorney from the Czech Republic, from the city of Ostrava, and I specialize in commercial and corporate law. Congratulations to all the speakers. It was very interesting. Thank you again for inviting me.
Thank you, Martin. So let's go. And Pallavi Divekar, please introduce your guest and then let him to introduce himself.
I'm so happy to introduce to you my colleague, Mr. Srinivas Sathe. He's from Kalyan, Mumbai. Mr. Sathe, please give us a 10-second introduction of what you do. Thank you.
Yes. Hello, good evening, everybody. This is very nice session over here. I congratulate all the participants. I'm university professor in India, as well as I'm a corporate lawyer and I'm a government pleader for government of Maharashtra. Thank you. Nice to meet with all of you. Thanks.
Thank you, Srinivas. Thank you, our colleague. Then I see Daniel Gosling. Who invited Daniel?
I did.
Please, Katarina,
Yes.
Introduce him.
Yes, Daniel is a very kind colleague of mine here in Nuremberg as well. He's in a different law office, and they have specialized on the Central and Eastern European parts. He's also an arbitrator, or rather, I think he would like to be an arbitrator. He's doing a lot of arbitration proceedings. But Daniel, you can introduce yourself now as well, if you like.
Thank you so much, Katarina, and thank you all for having me as a guest in that very, very impressive circle of experts around the world. So my name is Daniel Gosling. I'm a partner to the law firm BNT. Our firm is specialized in the Central and Eastern Europe, as Katarina said, and I'm head of our practice group for dispute resolution within the firm, counseling and arbitrations, and being also a litigation lawyer. Thank you.
Thank you, Katarina. Thank you, Daniel, for sharing your time with us. Okay, so Joseph, the stage is always already, again, yours for some minutes of Q&A. I hope guests, attendees have some. Or you
Mattia,
yes, sorry, Mattia Jamnik from Ljubljana, Slovenia.
Take your 50
minutes.
Apologize.
Okay. Hi, dear friends. Thank you.
We don't know where Slovenia is anyway, right?
Thank you for the. Thanks to everyone except Lara for the great presentation. I'm an attorney from Ljubljana, Slovenia. I specialize in IT law, personal data protection, and privacy. I'm also a member of WIL board and one of the founding members. I'm also in charge of WIL development in UK, Slovenia, Poland, and Turkey. Thank you.
Yeah, but I apologize, my fault, my bad. So Anđelka Radovanović from Belgrade.
Hello, everyone. My name is Anđelka Radovanović. I'm attorney at law from Serbia, Belgrade. I do corporate commercial law, and I'm also mediator. My colleagues from the law office are dealing with arbitration a lot. Some of them are arbitrators, so this topic was really useful for me. Thank you so much. And Lara, happy birthday once again. Thank you.
Thank you. Thank you. You can't forget your birthday in Madrid, Anđelka, right?
No.
It was so special. Yeah.
Thank you, everyone.
Thank you. Fabio Marinelli, can you hear us now?
No, he wrote that his microphone is not working.
Okay,
so I will speak in his name. Fabio is a very nice, great guy. He organized a great event in Naples, and we love him all. So thank you, Fabio, for being with us. And I'll buy you a new microphone next time I'm in Naples, which I hope
he is one of the top tax law in Naples and in the area. So, yeah. Okay. The stage is yours.
Thank you, everybody, for being with us. Now we will start Q&A. Please do it briefly, and whoever you would like to ask, say the name. And to the people being asked, write down the questions and give the answers all together, so it will be more efficient. Who would like to ask the first question?
I have one.
Break the ice. Oh, Marco,
I have one.
Icebreaker.
So I am not an expert in arbitration, but clients want to see the opportunities. So what are the criteria to determine the best place where to take an arbitration, according to topics or what, and what are the criteria for determining the costs, the investments, let's say, for an arbitration? So for all of you.
To all of them. Oh, that's going to take another hour. Margojata, please.
Okay, now I can hear you. I can speak. My question is especially for honorable judge. while he is also a lecturer at the university. Is this be a possibility for interesting development path for lawyers? Should the candidate have any special features? Maybe this is the alternative for student law also. Thank you.
Okay, I saw Kirti raising her hand. Did I get that right? No. So who would like to ask a question? Małgorzata, yes. Mattia, yes. Mattia, please.
Yeah, I have a question for Lara. So what if the arbitrator's bias has only been discovered during the proceedings? So you told us you can challenge the award before the court, but is there anything you can do in the arbitration proceedings? You know, not to be forced to wait until the final award. Thank you.
Great, thank you, Mattia. Anybody else? One of the guests, maybe? Okay, so please, let's start. Who would like to start with Marco's big question? Lara, please, and also, then Shaul. Yes, please.
Well,
Lara
the simplest way to answer that is where the parties have decided in the beginning, because arbitration is always done by contract or agreement. The best place to put arbitration is where the evidence is. So if you have a particular place where a lot of the people are, where a lot of the things took place, then you will choose that particular place. The only time I would not choose that place if it had a terrible arbitration law to begin with. Like say all the evidence is in the Mongolei, I would not really go to arbitration in the Mongolei because they have no experience with arbitration and sometimes you need court support. As for the money, the more arbitrators, the more costs. There is ways to expedite arbitration. There's whole books written on it, but basically you can say if you exclude any kind of review, which is possible in some jurisdictions like Switzerland, if you reduce the number of arbitrators, for example, to 1 rather than the usual 3, and if you limit the time that the arbitration can take, customarily expedited arbitration is supposed to be about 6 months from the time the arbitration notice is filed to the time the award is given. That way you can reduce costs.
Thank you, Lara. Shaul, would you like to add something?
I believe that the parties have the power to shape the arbitration agreement and within this frame, they have also to decide, or at liberty also to decide where the arbitration will take place. So one thing that is important, noticing vis-a-vis what we spoke here today, is that you have to know the arbitration law applicable in that country. And you have to make sure the arbitration takes place under that law. In Israel, usually there is 1 arbitrator, 3 is the exception. And of course, the less arbitrators, the less costs. Much of the cost is dependent on lawyers and parties. If they are cooperative with the process and do not try to complicate a simple case rather than to simplify a complex case. So that's the main answer. At least in Israel, an arbitrator is usually asked what is the cost. The cost may be based on hours, maybe based on a percentage from the amount claimed, maybe a combination of both, but the rules should be known to the parties before the final consent to start the arbitration with this specific arbitrator. Thank you.
Thank you, Shaul. Please continue with the question of Małgorzata about the university lectures.
There is no formal demand of special studies as a condition to be an arbitrator or even In many cases, parties prefer to come to a retired judge. Many other cases are to a retired and well-known commercial lawyer, or even an engineer if the case is usually about engineering work, or other experts. Some of them are also lawyers, so it could be very interesting if you take such a person for a specific case, specializes on this. There is now in Tel Aviv, just last week, a week ago, exactly a week ago from today, I had a lecture in Tel Aviv University where there is an institute that enables people to learn how to be arbitrators, but this is not a precondition to be an arbitrator. I hope I answered the question.
Thank you, Shaul. Now, Matthias' question. Lara, please.
Can you repeat the question, please?
Matthias.
Well, let's say that if the bias becomes obvious during the proceedings, you said you can of course challenge the final award, but is there any remedy that you can use during the proceedings so you don't have to wait for the final award, because it would be, beneficial to the parties, that it could save time?
You actually have to. If you don't, then you lose the right to challenge.
Okay.
What you would do is you would make a request to the arbitration panel and say, well, this person, you are biased. What do you have to say to that? Do you want to recuse yourself? And if they say, no, 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 I want to continue, and you still don't think that way, then you can go to court and have the issue decided. But generally, an arbitrator will then recuse himself, and the whole shebang starts from the beginning, because most of the proceedings will have to be repeated. Sometimes the arbitrators decide that you can go from the point that has started there, but I personally wouldn't recommend it, because then if you do, there's always the argument that at least part of the proceedings were supervised by a biased judge, and thus the judgment itself was tainted. But you have to actually challenge immediately, first by going to the arbitration panel and saying something, and then if that doesn't help, to the court.
Thanks, all clear.
Thank you, Lara. Please, Shaul, yes.
I just want to say it's almost word by word exactly the same rule in Israel.
Well, the world is a small village. Yes, please, Francesca.
It's the same in Italy, because you have to challenge immediately if you become aware of it, also during the procedure. And we have really short terms to do this, because in the arbitration we have 10 days since the notification of the appointment of the arbitrator, or from the day you became aware of the lack of impartiality, of independence. And for the judge are 2 days. The term. So there are really short, so pay attention in Italy to it. For the cost, just I want to say that in Italy, with the administered arbitration, the arbitration chamber, they have a fee schedule. So if you decide to have your arbitration there, you can know before how are going to be the costs of the arbitration. And also in Italy, the arbitrator fee have to be established according to the minister decree for the lawyers' fee, but it's not always like this.
Okay, thank you, Francesca. I think we came to the end of our session. I would like to thank everybody who came. I would like to ask everybody to smile, so I'll put the print screen. Let's smile, 1, 2, 3. Thank you.
Please,
Happy
Joseph,
birthday
send
to
me this
Lara.
picture, okay?
I will. Happy birthday, Lara. Thank you, Shaul, for coming. I hope you enjoyed yourself in the presence of the colleagues from all over the world. Actually, 25 lawyers in one room, that's about, in our organization, that's about 300 years of legal experience. So you think about it in one room. Thank you, Zoom, for making it happen. And thank you, Marco, for being the spark. And yeah, Marco, I love you. What can I say?
I love you too. Thank you very much.
Allah.
Ciao.
Ciao, everybody.
Thank you very
Thank
much.
you.
A recording will be available in a few
Thank
minutes.
you.
Okay. Ciao.
Okay.